Welcome back to Bankruptcy with Ben. In today's episode, I'm going to get into a story which some people might say is yesterday's news, but in reality, yesterday's news is still very much today's news, and that is FTX. FTX, as I'm sure everyone knows, was a crypto exchange founded by Sam Bankman-Fried in 2018. Sam Bankman-Fried, otherwise known by his initials, SBF, founded this platform for crypto, which he called FTX, and was wildly successful, including having its naming rights on many, many buildings. For example, the Miami Heat's arena was for a time called the FTX Center, all the way until its stunning collapse in 2018. In 2022. It was founded in 2018, and then it had a stunning collapse in November 2022, at which time SBF was kicked off as CEO. A new CEO named John Ray was put in his place. Mr. Ray took the company into bankruptcy, which is where it's been for the last 2 years. Now, FTX has recently been in the news again because it has filed a whole slew of lawsuits, which I want to get into in a minute. But the other reason why FTX is in the news is because crypto is back in the news. And crypto is back in the news in no small part because of the presidential elections. Trump, for his part, has campaigned on being the crypto president. Among other things, he said he's going to fire SEC Chair Gary Gensler.
Day one, I will fire Gary Gensler and appoint a new SEC chairman.
So you can see there the crowd going wild. Obviously, the crowd did not like Gary Gensler. They felt that his policies, again, were just strangling crypto. So is crypto good? Is it bad? Maybe we'll get into that in another video, but it's very much in the news. Now, the collapse of FTX raises another question. Was it due to crypto inherently being a quantity that is not really backed by a real value and therefore is doomed to fail because crypto does not have a real value? Or was it more similar to a garden variety fraud like Bernie Madoff and Enron? What we'll see, and I think what's come out, is regardless of whether or not you view crypto as a positive or negative or neutral, there's no question that there was enormous levels of fraud. And without that fraud, I think FTX would have been in a very different place than it is today. And one of the other key points is that FTX has proposed a plan in their bankruptcy under John Ray to repay all the creditors. So that means everybody that had a deposit with crypto, according to what FTX is proposing, is going to get paid back in full. So that would seem to also weigh towards this, the view that crypto really does have a value to it. So let's get into the bankruptcy filing. Let's take a look at this lawsuit. But before we do that, there's a few charts I'm going to go over because there's a whole web of corporate entities and individual entities, and a lot of what was done in this bankruptcy is kind of untangling all that. And that's something that comes up all the time in these corporate filings, is there's many different levels of corporations. You have to kind of dig through it all, trace the relationship between each entity, each individual, where all the money is going. So I've put together a few charts which I think are going to be helpful as we go along this journey. So let's take a look. Okay, so here's the complaint. It's FTX Trading Ltd. That is the name of the bankruptcy company. And now Who are the plaintiffs? We have FTX Trading Ltd., Almeida Research Ltd., West Realmshires Inc., West Realmshire Services Inc., and Almeida Research. And they're suing FWD.US Inc. So who are all these different players? So I've created a little chart here to help us. Okay, at the very top is SBF. He owned 100% of an entity called Paperbird Inc. Paperbird Inc. in turn owned 80% of FTX. FTX was owned in 20% by a variety of other shareholders. Now, these 20% other shareholders, they owned 22.25% of an entity called West Realmshires Inc. West Realmshires Inc. in turn owned 100% of West Realmshires Services Inc. And you see that all the time when there's different entities and they have some kind of relationship. So you don't want to change the whole name, so you kind of add on another name. And you see that the entities are related. Often it's the same individual or set of individuals that control it, and they're being operated for similar business purposes. So that's it, SBF at the top. Now the other side, there's an individual named Gary Wang. Okay. I'm sorry. SBF now owned 90% of a company called Almeida Research LLC, and Gary Wang owned 10% of Almeida Research LLC. Now, Almeida Research LLC owned 100% of Almeida Research Ltd. Okay. Gary Wang also owned 16.9% of West Realmshires Inc. And then Nishad Singh, another individual, owned 7.8% of West Realmshires Inc. And the remainder owned by, yep, that's right, SBF, owning 52.99%. And then again, West Realmshires Inc. owns 100% of West Realmshires Services Inc. We'll come back to the chart, reference it as necessary. That's kind of just the basic flow of the different players. Okay. So what is this lawsuit being brought for? Now, one thing that's important to understand is in bankruptcy court, you have the ability to file lawsuits under the umbrella of the main bankruptcy proceeding. And that's something you see time and time again. So that means the actual caption of the case will look like this. In re FTX Trading Ltd. Et al., because FTX Trading Ltd. Is the corporate entity that's in bankruptcy. And now, within that proceeding, they're going to start a new lawsuit. I'm sorry, not a new lawsuit, because a bankruptcy filing is kind of a special proceeding. It's not the traditional litigation. It's a specialized proceeding which has its own set of rules and regulations. But it's not necessarily adversarial in the sense that there's a plaintiff and a defendant. There's a petitioner, meaning you file a bankruptcy petition with the court, and you're petitioning the bankruptcy court to grant you certain relief in bankruptcy. And now, underneath that umbrella, you can file a lawsuit, which is what they did. So, let's back up a second. What does FTX hope to accomplish by filing for bankruptcy? Let's say there was all sorts of fraud going on. Okay, there's fraud. What is the point of a bankruptcy? And if everyone's going to get paid back, then where did all this money come from to pay them back? Either they had money and they did not need to file for bankruptcy, or they didn't have money and they needed to file for bankruptcy. But if they're all getting paid back, where does this money come from? So that brings me to one of the kind of core things that can be done in a corporate bankruptcy. Now, it's important to know whichever side of the aisle you're on, whether you're the debtor entity or whether you're a creditor or whether you're a third party that gets wrapped up in one of these lawsuits. And one of the most common lawsuits is what's called avoidance. Avoidance means we're going to undo a transfer. So if I give my Joe DiMaggio card to my next door neighbor, Bob, as a holiday present, and then the next day I file for bankruptcy because I owe $1 million to Bank of America for the loan they gave me to start up my gym, and I didn't pay them back. Well, this Joe DiMaggio card could be worth a lot of money. And so the concept is, if I gave my neighbor Frank my Joe DiMaggio card, which was worth $500,000, in order to get that card out of my name so that Bank of America cannot go ahead and take that card and sell it to repay themselves the money that they're owed, that's called fraud. And in that case, the bankruptcy trustee can come in and sue my neighbor Frankie and say, Frankie, you have no right to get that Joe DiMaggio card, and it's fraud, and Ben gave it to you for the sole purpose of getting that Joe DiMaggio card out of his name so that he could file for bankruptcy and essentially screw his creditors. And that's what's going on here. That's one of the most common types of bankruptcy actions. So to answer the question, in November 2022, FTX did not have access to the money that they're now going to be suing for because the money was transferred to these third parties, namely FWD.US. But in bankruptcy court, they can sue FWD and take the money they get from the lawsuit and use it to repay the creditors. Now, from the creditor's perspective, or even not from a creditor's perspective, if you're Frankie, you say, hey, what did I do wrong? It's not fair. I didn't know what Ben was doing. And so you might have some valid defenses to that kind of lawsuit. So it's very, very important if you're Frankie, you hire a bankruptcy attorney. Even though you're not in bankruptcy, you need to know what's going on and understand that there are defenses. For example, one kind of defense, a case I had recently, involved a corporate entity. Let's just say my client's name was Punching Bags for Us, LLC. And it was a New York corporation named Punching Bags for Us, LLC. Now, there was another corporation that went into bankruptcy. Let's call the corporation, Smiley Face LLC. So Smiley Face LLC filed for bankruptcy and had some dealings with a company called Punching Bags for Us LLC. So they sued Punching Bags for Us LLC and said, for all these reasons, you got to pay money back. So now Punching Bags for Us LLC came to me and said, hey, what's going on? I never heard of this company. I never heard of Smiley Hearts LLC. I don't know who they are. I don't know what happened here. I don't know what's going on. So they needed representation. So we did a little digging, and it turned out it was a case of mistaken identity. And there was another corporate entity by the same exact name, Punching Bags for Us LLC, but they were in fact a Florida corporation, not a New York corporation. And that was the corporation that the debtor, Smiley Faces, had done business with. So eventually we got it all sorted out and we resolved it. And they went after the actual corporation that was the correct company. So the point is just to give you an example of different ways that you can potentially defend against these kind of lawsuits. And how you can be an innocent third party wrapped up in a bankruptcy filing, even though you're not the one that is having financial trouble and you're not the one that's in bankruptcy. And sometimes it's just the cost of doing business. If you're out there doing business, if you're a bank, if you're a lender, you're a trader, whatever it is that you're doing, it's going to happen. You're going to get caught up into these, and you have to understand that it's just a part of business. So don't freak out if you get wrapped up in a bankruptcy litigation. Just know if you have good bankruptcy counsel You can have your interests properly, properly represented. And very often you can actually have a very good resolution worked out. All right. Back to our case at hand. What's going on here now is FTX and all these other entities are now suing FWD to get money back. Okay. Nature of the case. We're going to go through some of the key points just to kind of show you the structure of how these lawsuits work. So they're bringing an adversary proceeding. Adversary proceeding is just a fancy name for lawsuit in bankruptcy court. And they're bringing it to they're quoting the different statutes that give rise to this kind of lawsuit. And again, if you're going to bring a lawsuit, you need to say why you're entitled to bring that lawsuit. So they're saying these are the statutes that give us the power to make the claims that we're making. Okay. So some of them are bankruptcy statutes. Some of them are Delaware state specific laws. And all of them basically say the same thing, that you can't transfer something to someone else for no value. And if you do, then that transfer can be undone. Okay. Now, here were the transfers. September 30th, 2021, $200,000 went out from Almeida LLC. April 18th, 2022, $885,000 went to Almeida. May 27th, 2022, $520,000 went to Almeida. June 15th, 2022, $200,000 went to Almeida. Okay. Now, who are the parties? FTX. FTX was registered in the Bahamas, and it operated a digital asset trading exchange, like we said. Okay. Almeida, British Virgin Islands Company. We'll go back to the chart. The chart explained this all. I'll just run through this. Plaintiff, Delaware Corporation, 53% owned by SPF, 17% owned by Wing, 7.8% by Nishad Singh, 22.5% owned by other shareholders. And again, this lays out the rest of the different entities. So if we just go back here and we see it's basically exactly the same as we said before. Now, who else is there? We discussed the corporate entities. We have Sam Bankman-Fried, and then he co-founded Almeida, which was another entity. And then in 2020, he established a separate group of operating entities that operated a digital asset exchange for U.S. persons. That was FTX US. So he had one in the Bahamas, and he had one in the U.S. And he was the majority owners, and he controlled all the operations of all the different entities. Again, these are the other individuals that we already discussed. Now there's another entity, Guarding Against Pandemics and Planning for Tomorrow, Inc. They have such nice sounding names, don't they? Everyone wants to guard against a pandemic. Everyone wants to plan for the future. And these were Delaware nonprofit corporations funded by Sam Bankman-Fried. How did he fund them? Not from his own money, but with the assets of the corporations. Okay, that's kind of just the key point. Jurisdiction and venue. What does this mean? This just means jurisdiction means how do you know which court to file a case in? Which court has the power to hear the case? So this, again, just says this is the federal rule that gives us the power to do what we want in front of this case and why we're bringing this case in front of this bankruptcy court, and that it arises and relates to the main Chapter 11 case. And again, this court has jurisdiction because of the amended standing order of reference. And what that means is just kind of a quick constitutional background is Article 3 of the Constitution sets up district courts. Bankruptcy courts are actually a power of statute. They're not in the Constitution. So technically speaking, there's no constitutional provision that gives bankruptcy courts power to hear a case. So what happened is, in this federal statute, they said a district court will automatically refer cases arising under bankruptcy to these specialized bankruptcy courts. So that's all this means. Now, venue, why are we filing it in this district? Because that's where the bankruptcy was filed. And again, here are the specific statutes that let us bring the claims that we want to bring. Okay. Now let's get into some of the facts. Again, FTX operated a cryptocurrency exchange and trading business, and they faced a severe liquidity crisis that necessitated the filing of these Chapter 11 cases on an emergency on November 11th and November 14th, 2022. Additional factual background relating to the business, it's set forth in the pleading of John Ray. Again, John Ray was the new CEO, and he filed, as we've seen, the declaration, which lays out the history of the case. The FTX insiders, who are they? Sam Bankman-Fried, Caroline Ellison, and some of the other individuals that owned certain controlling interests in the various corporate entities. And what do? They took advantage of the FTX group's lack of controls and record keeping to perpetuate a massive fraud. So what this is saying is that there were no corporate controls in place to ensure the separation of different companies and separation of individual assets and different customers, and having each customer's assets specifically in specific accounts and then being able to track everything. So there are no controls in place to make sure that things were done properly, and there were no controls in place to ensure that people were not able to misuse or steal from the company. Normally there's kind of password protection, only certain people can access things of that nature. They didn't have any of the standard controls in place, and they didn't keep records, and this led to massive fraud. What did they do? They bought mansions, they bought jets, and what else did they buy? They bought influence, meaning they made political and charitable contributions, meaning they donated to politicians in order so they would have influence with the politicians, and they can tell the politicians to pass laws that would be favorable to their businesses. Now, all the FTX insiders, except for Bankman-Fried, have pleaded guilty to crimes perpetrated through the practices that facilitated the transactions herein: wire fraud, conspiracy to commit commodities fraud, money laundering, all sorts of exciting white-collar crimes. Now, in connection with his plea, Wang, let's see again, who was Wang? Gary Wang, who owned 10% of Alameda. And what did he say? He admitted that he made changes to the FTX.com code to give Alameda and its affiliates special privileges on the FTX platform, including to allow Alameda unfettered use of assets on the FTX exchange. So now Alameda, which is another company, again, back to their chart, who is Alameda? Alameda is another company owned by SBF, allegedly separate. You see here, Alameda does not have any kind of overlapping ownership with FTX. It's allegedly completely separate. However, Alameda had unfettered use of assets on the FTX exchange. So Alameda was essentially stealing, looting from FTX. There was no relationship between the two. There was no kind of governing document that entitled Alameda to somehow take distributions from FTX, which it wouldn't be entitled to anyway. Again, who are the owners of FTX? 80% is Paper Bird, 20% is other shareholders, and of these 20% of other shareholders, none of them are Alameda. Alameda does not own FTX at all, completely separate, or it's supposed to be. Yet, despite that, it was looting FTX. Using these special privileges, the FTX insiders frequently caused FTX group entities, including the plaintiffs, to misappropriate funds from the FTX exchanges for their own benefit, including to make speculative investments for which they overpaid and political and charitable donations. So, Alameda is taking money from FTX, and then Alameda giving the money to Sam Bankman-Fried, to Gary Wang, possibly to Nishad Singh, or as Alameda is giving that, who's actually controlling it? SBF. So SBF is directing all of this kind of funny business, and all for his own gain. Before his conviction, Bankman-Fried repeatedly and publicly claimed that Alameda LLC operated as a wholly separate entity from FTX.com. And again, that's the way, in theory, it looks on paper. But that's not the way it was. The FTX insiders were aware at all relevant times of the special privileges on the FTX platform, and that Alameda LLC was borrowing, i.e. looting billions of dollars from FTX.com in order to, among other things, finance sham loans from Alameda to the FTX insiders. So again, back to our chart, what was going on? You have FTX and you have Alameda. Let's see if I can draw here, or if this might spectacularly backfire. No, this is going to spectacularly backfire. So let's go back. No, that's not going to work. But you can see again, okay? They're all supposed to be completely separate, and they're not separate. So Alameda borrowing money from FTX. Here is Alameda borrowing money from FTX and then lending the money to SBF, to Gary Wang. Now, Ellison admitted that she was aware of this arrangement, which permitted Alameda access to an unlimited line of credit. So Alameda can just use FTX as its piggy bank. Alameda using FTX as its piggy bank. Borrow as much money as they want. So people put their money with FTX, had their money with FTX, not with Alameda, with FTX, and now Alameda just wants a piggy bank. And they can do it without being required to post collateral, meaning, and normally, if you want to give someone a loan, you would say, well, how do I know you're going to pay back the loan? You collateralize it. You say, okay, well, if you don't pay back the loan, then I can take certain assets of yours. It could be a house, it could be real estate, all sorts of things, right? And not only that, they didn't have to pay interest either. And they didn't have to, or subject to margin calls or any liquidation protocols. So any normal methods that would be used for a loan were not present here. It was their personal piggy bank, which they did whatever the hell they wanted with. Okay. It gets worse. FTX insiders defrauded customers and other creditors of FTX Group to make political contributions. Again, all this is talking about SBF. He knew about these special privileges, and he was aware that Alameda was borrowing billions of dollars from FTX to finance loans from Alameda to SBF and to make donations to causes favored by him, saying, hey, I give money to this politician, you look the other way and let me do what I want. And then at the direction of SBF, Ellison, Wang, and Singh, the FTX group papered loans to FTX executives, including hundreds of millions of dollars earmarked for, again, political contributions and speculative investments in other companies. Again, Bankman-Fried directed Singh, Salam, as well as other insiders and executives to make political donations using the assets of the company as straw donors to conceal the identity of the true donor, Sam Bankman-Fried. And that violates federal election laws, which prohibit people from making contributions in the name of another person or knowingly permitting their name to be used to effect a contribution, and prohibit corporations from making contributions. So, not to get into federal election law, that's not what these videos are about. But one interesting point is you see how bankruptcy kind of encompasses so many other different areas of law. And if you're a bankruptcy attorney, it's important to really get familiar not just with bankruptcy, but very often you're going to have to get familiar, at least to an extent, with a lot of different other areas of law. So, they violated not just fraud, but violated federal election laws by using company assets to lend money to themselves and to have the company make donations to political candidates and politicians, people running for elected office, without disclosing the individuals behind it. For example, by design of Bankman-Fried, Salam primarily made contributions to Republican candidates or Republican-affiliated PACs or super PACs. So, this other guy, Salam, is being told by SBF to make contributions. So, he's not making the contributions in his own name. I mean, he is doing it in his name, but it's coming from money given to him by SBF. Records identified by the debtors show that Salam served as a conduit or straw donor for Bankman-Fried's donations to Republican Party candidates, which Bankman-Fried and Salam sought to obscure, meaning they don't want anyone to know where the donations really came from, and that Salam was rewarded for his participation in this scheme. Through this scheme, Salam made millions of dollars in political contributions in his own name to Republican Party candidates and causes as a straw donor to conceal the identity of the true donor, Bankman-Fried, in violation of campaign finance laws. And Bankman-Fried was getting the money by looting the company. Salam stated at his plea hearing that tens of millions of dollars in campaign contributions he made in his name were funded by transfers from the bank accounts of an Alameda subsidiary. He acknowledged that while the time these funds were categorized in both his and Alameda's ledgers as loans, meaning they were lent to him, he understood that the loans were going to be forgiven by Alameda, by SBF, etc., and he never intended to repay them. So that's just a brief snapshot of the election law violations. Pretty egregious. Now let's get to the heart of the matter, which is also related to this election, in a sense related to this election law sphere. Now, what happened? The defendant was incorporated on March 8th, 2013 as a nonprofit by its founders, Mark Zuckerberg and Joe Green. So, I don't know who Joe Green is, but everyone knows who Mark Zuckerberg is. Defendant describes itself as a bipartisan political organization whose aim is to enact immigration and criminal justice reform by influencing policymakers at the local, state, and federal levels. Now, nothing is really bipartisan. When they say bipartisan, it means bipartisan because they're hedging their bets. They want whoever's in power to be favorable to them. So these very wealthy people like Mark Zuckerberg sets up his nonprofit whose aim is to enact immigration and criminal justice reform by influencing policymakers at the local, state, and federal levels. In reality, this is just Zuckerberg has a cause that he wants to use to promote himself and his own brand, and he's buying support by paying off politicians on both sides of the aisle. He's hedging his bets. And Sam Bankman-Fried did the same thing by basically now giving money to Zuckerberg or Zuckerberg's nonprofit to then funnel out to politicians on both sides of the aisle. On August 16, 2021, plaintiff Alameda LLC transferred $1 million from a Prime Trust account containing commingled customer assets held in its name to an amalgamated bank account held in the name of Planning for Tomorrow. Okay, so let's back up. The next 3 paragraphs each detail various transfers that took place between various corporate entities, plaintiffs, and defendants. I've actually created charts for each set of transfers. It's going to make it a lot easier to follow. So, the first set of transfer, Alameda LLC. They transfer, and now who is Alameda LLC? Again, Alameda LLC is this other company that was quote-unquote independent of FTX that was 90% owned by SBF. So, on August 16th, 2021, they transferred $1 million to Planning for Tomorrow into this bank account. Now, Planning for Tomorrow then went ahead and transferred $300,000 of that money to this Guarding Against Pandemics, GAP, into their bank account. And then on September 3rd, 2021, it was transferred to the ultimate recipient, defendant FWD. It's a whole line of transfers. So that's the first one. Next, Alameda transfers $10 million to Bankman-Fried. So here we see Alameda, and it gives $10 million to Sam Bankman-Fried. Bankman-Fried transfers $10 million to Guarding Against Pandemics. So Bankman-Fried got the money from Alameda, gives it to Guarding Against Pandemics. Now, Gap then transfers $885,000 of that money to FWD, and now FWD has $885,000. Okay, so going back, now we see $200,000, $800,000, $885,000, and now the final set, Alameda transfers $5 million to Sam Bankman-Fried. Bankman-Fried gives $5 million to Guarding Against Pandemics. Guarding Against Pandemics, May 27th, transfers $520,000, and then June 15th, transfers another $200,000 all to FWD. And that's how we got where we're at, with a total of $1.8 million. And again, these transfers were all funded by the debtor's assets, initiated by FTX insiders via transfers from the debtor's account before subsequently transferred to an account held by defendant. Again, all that means is there were intermediate levels. They wanted to conceal it, and they wanted to make it very, very difficult. And that's why we had to make all these fancy charts so you can see what happened. Because they wanted to obscure it, and they wanted to put as much distance between the individuals and the ultimate recipients as possible. The transfers to Bankman-Fried, then to defendants, were part of a single integrated transaction whereby funds that were property of the corporate entities, the debtors, were transferred to the defendant. The transfers were also part of a carefully coordinated and deliberate scheme by SBF to violate federal campaign finance law through the use of strawman donors. So that's more just kind of to throw them under the bus. adding kind of, fuel to the fire, because bankruptcy courts, you have to have some familiarity to understand the background, but obviously a bankruptcy court is not the proper domain to prosecute campaign finance violations. So they're not asking the court to find any kind of campaign finance violations. They're just doing it to show how bad of an actor SBF really is. Okay, now we're going to get into the causes of action. Fraudulent transfers pursuant to 11 U.S.C. 548(1)(a). Again, these are all just the various federal bankruptcy statutes which outline the different requirements that must be met in order to kind of prove this case to undo these transfers and bring these transfers back into the pool of the bankruptcy estate that would then be taken and redistributed to creditors. And now the important point is they have to allege this fraud with specificity. And they say each of the transfers were made with intent to hinder, delay, or defraud present or future creditors. Accordingly, each of these transfers should be avoided. Count 2. Fraudulent transfers pursuant to 11 U.S.C. 548(a)(1)(b). And again, they go through all the elements, but it's really the same thing. Count 3. The Delaware statutes, it's the same thing. Count 4. Again, they're really just kind of throwing in the kitchen every single law that could possibly kind of give rise to what they wanted to say, they throw in. It's all saying the same basic thing, which is you can't transfer something to someone else for no value for the sole purpose of getting it out of your name. Think back to the Joe DiMaggio card analogy at the beginning of the video. That's essentially what they're saying. All right? And that pretty much sums up everything else. So that, in a nutshell, is what's going on. That is the complaint. We went a bit lengthy, but you can see kind of the depth of the fraud and what needs to be done to undo all that. Again, this is not to say that FWD is not without defenses. Again, it's not a criminal standard where you're innocent until proven guilty, but the burden of proof still lies on the debtor here. And they have to prove that there was no value. So theoretically, Zuckerberg could come back and say, oh, I was providing some kind of consulting service to Bankman-Fried, to FTX, whatever, and here's the value, here are the services I provided. So everything was really kind of square and above board, right? It seems unlikely here. It's probably going to settle for some kind of money, but that's it. We'll stay tuned on that. We'll keep a track of what's going on. Hope you all enjoyed. Stay tuned. Don't forget to like, comment, and subscribe, and I'll see you all in the next one.